That's not the hearing part.
Yeah, just turn it off.
Thank you, Chris.
Okay. Can you hear us now? Thank you so much.
Okay, yeah.
A thumbs up doesn't mean they can hear you.
My husband's just said that he can.
You could just say that you are.
Okay, so I'm going to ask for, even though we did, everybody raised their right hand and testified, I'm going to ask to do that again. So you guys, if you think you're going to testify, so would you please raise your right hand? Mrs. Oldfield, Bob Fisher. And are the witnesses, are you planning to testify at this hearing? Okay, thank you. So please raise your right hand. Do you swear the testimony you provide is the whole truth and nothing but the truth?
Yes.
Yes.
Thank you all so much. And okay, so we do have the report from the state, from the DEC. So fortunately, we're going to be able to move ahead here. We do also have, we read your comment about exhibits and not being sure. So John spent some quality time putting together a whole list of exhibits. And
Oh, I did the same though. Did you see that? I emailed to Alex last week.
it's a little different,
Right.
but we have some that perhaps you didn't get. I'm sorry.
Just a point of order, to clarify, isn't the DEC information a draft decision of the 30-day comment period?
Yes, that's correct.
Okay.
Yep, it's in its comment period. It ends, I think, July 8th, I believe.
So
That's correct.
it could change.
Yep. So anyhow, I thought that we would start by going over the exhibits, and John is still our case manager, and we got all your goodies from today.
Yep, as well as goodies from us. So I'm not going to go through every single exhibit, but I am going to start where we left off at the last hearing, which is with, I'm just going to note, this was introduced at our last hearing, which was Exhibit 24, was a site plan for 220 Lake Rapunda Road. You referenced it, Heather, as a part of a DC's application, but it was not the complete application. I have added that as a later exhibit, so the complete application is part of the record. The next exhibit is Exhibit 5, which is assignment of agent for Jessica Roberts. Exhibit 26 is assignment of agent for Bob Fisher. Exhibit 27 is an email from Carol Boyes to Alex Miller, copying John Gannon, dated May 23rd, 2026. Exhibit 28 is an email from Carol Boyes to Alex Miller, copying John Gannon, dated June 1st, 2026. Exhibit 29 is an email from Joan Yakura to Alex Miller, copying Cheryl LaFlamme and John Gannon, dated June 2nd, 2026. Exhibit 30 are emails.
Are you excuse me for interrupting, are you listing these out just so that we have the same list? Because I'd like to address some of these at a later.
Oh yeah, you can, no, we're just listing them out at this point.
All right.
Bob.
Yeah, we just want to make sure that.
No. You can address them at a later point. This is just running through the exhibits, which is usually where we start a DRB hearing. Exhibit 30 is emails from Alex Belisle, I think, and Misha Center from the Vermont Department of Environmental Conservation, dated June 8th, 2026. I just note the document sent did not contain the draft permit or the updated application. These will be marked as separate exhibits. It doesn't matter. They're going to be in the record.
Yes, because I did mention in my email
Yeah,
about this, where you could find
the way I received them, they did not have either the application or the draft decision.
No,
But
the link was, yeah.
but they're in the record, so no problem.
Thank you, appreciate that.
Next is email from Eric Baker to Heather Oldfield and Bob Fisher, dated June 10th, 2026. Exhibit 32 is a message from Wayne and Pam Paradise to FAO Design Review Board, Town of Wilmington. Message is undated and there's no indication that it was a text. Exhibit 33, email from Jessica Roberts, Wilmington Zoning Administrator to Ray Reed, copying Scott Tucker and Adrian, the town attorney, dated August 15th, 2025, and attached memorandum from Jessica Roberts, Wilmington Zoning Administrator to Ray Reed, dated August 14th. Exhibit 34, emails to and from Alex Miller, Wilmington Zoning Administrator, and Ray Reed, dated October 9th and 10th, 2025, including notice of alleged violation dated October 9th, 2025. Exhibit 35, emails to and from Vermont Department of Environmental Conservation and Ray Reed Construction, dated February 13th, 2026, January 20th, 2026, December 11th, 2025, and November 6th, 2025. I will note that many of the images and attachments did not come through as sent to us. Exhibit 36, email from Jeff Lowy to Heather Oldfield, copying Bob Fisher, dated June 12th, 2026. Exhibit 37, email from Cheryl LaFlamme to Development Review Board, dated June 15th, 2026. Ray ex parte communications and attaching email from Joanne Yakura, dated June 2nd, 2026. Exhibit 38, memorandum from John Gannon to Development Review Board, Ray ex parte communications, Attached emails from Carol Boyes dated May 23rd, 2026, and June 1st, 2026, and Joe Nikura dated June 2nd, 2026. In just a moment to explain Exhibit 37 and 38. We are a quasi-judicial body. Any evidence or information should be provided in a hearing, like we are doing today. People should not directly communicate with any individual member or all DRB by email or any other communication. That's considered an ex parte communication and is a problem. And that's why you see those two memos in the record, because while they were sent to us, we did not have any direct communication with either the people who sent those emails.
John, there should be one addition. Sorry, I also sent that same memo because I received the email as well from.
I have a copy of that.
I did not see that.
Yeah,
I have a copy of it.
All right, we'll make that Exhibit 42. Okay. Right.
It's a memorandum and then a PDF of the email from,
Yeah. Memo.
and I did not respond.
Thank you. So that's marked as Exhibit 42. So now on to Exhibit 39, which is an updated shoreline protection individual permit application dated May 11th, 2026. Exhibit 40 is the draft shoreline protection individual permit dated date added June 8th, 2026. And Exhibit 41 is emails from Heather Oldfield to Jessica Archambault dated June 15th, 2026, and to Alex Miller dated June 11th, 2026. And as we just mentioned, Exhibit 42 is an email from Crystal Holt, Ray Ex parte Communications. Are there any other exhibits?
No, but do we need a minute to align our alignments?
Well,
Or you good? You good?
I'm good.
Good? Okay, sorry.
Some of our exhibits, because of what you've added, are a little different in our numbering, but I think they're one or so off.
Yeah.
We should be able to.
Yeah, refer to them
If
what they are rather than.
when we're referring to it, if there's confusion, we'll try to use the town's master exhibit list and change ours.
I'll try to
on
find
it.
it in here.
So
Okay.
I think we're okay.
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 With regard to the ex parte communications, I get where you've disclosed that. It's a small town. People don't necessarily understand what they're supposed to do and not do. And from the standpoint of our application, we're going to go with that. We're okay. It's good that you disclosed it versus not disclosed. Okay. As another preliminary matter, with regard to some of these, what you've got on an exhibit list, while everyone has a right to attend a public hearing, that does not necessarily make anybody here an interested person pursuant to your ordinance or your statute. So with regard to the letters, emails from the Boyces, Joanne Yankura, those folks, we would object to them as an interested person because they are not abutters, for one thing, and they, in their exhibits, have not shown anything whereby there is a physical or environmental impact on their particular interest or their property. They're way down the road from this. So we object to that as an interested person status. That's usually something that's brought up in environmental court, but I raise it here because the town in its ordinance has the same standard as.
We do allow neighborhoods, and that is a part of the 24 VSA.
But it talks about the immediate neighborhood, which we would, for the record, challenge. And there also has not been any petition by folks for party status. So we, for the record, object to that.
So Alex did reach out to Joanne and make sure that she was aware of the group of 20, just so everybody's aware of the rules.
May I ask then for you to show us the petition of the group of 20 today?
They did not petition.
Okay, if there's
But
no,
I just asked Alex
Right.
to send her that when she sent in that email. But
So
there
they
is-
are not
So
petitioned.
there is a group of 20?
No, there is not.
No, there is not. But that's allowed under
Yes, I
the
understand
state
that. I
statute.
understand.
Yep.
So next, I'd like to jump in here as to what we're here on. We're here on an after-the-fact application for what's built at the Old Field property, okay? That was requested, and in a notice of an alleged violation, there's an opportunity to cure, and one of the ways to cure that was to file this application, which the Old Fields did, and they did that, in fact, last August. At first, it was deemed incomplete, and that's why we put in a lot of these emails back and forth between whether it's the zoning administrator and whether it was Ray or the Old Fields, or then it became you have to apply for the shorelands permit, which they did right away. That went back and forth in many machinations of the permit, what was needed, site plans, more photographs, and lots of mitigation that the Old Fields did, which ultimately resulted in the shoreline mitigation draft permit. And we're finally here before you tonight because we've been waiting on that for quite some time. But the reason that we put in a lot of those emails is to show that this was not ignored from last summer to now. There is a correspondence, if you look carefully at the to and from, all the way through that. So I'd just like to point that out. So, and we're not here on any appeal of a notice of violation. That's not before you tonight. Also, there is nothing with regard to those notices of violation that had anything to do with the rear deck. That actually had to do with the retaining wall, which was removed as asked for, and with regard to the front entranceway mud. So I point that out just to have the scope of what we're actually talking about narrowed, because I'm a little bit late to the game here in terms of coming in. I wasn't here at the very first hearing, but as I understand it and having viewed the hearing, it, in my view, got somewhat out of hand in terms of what the actual application before the board is, okay? Next, there are a few corrections to be made, and I think this is in the email from Heather Oldfield. But with regard to the zoning administrator's summary, there's some mathematical errors there, which may not seem like a big deal, but when you get to mitigation and increases, it does make a difference. On the second page, under as-built conditions, he has the total footprint of the front mudroom as being 301 square feet. It's actually 189. If you do 9 times 21, that's 189 square feet. So it's just a simple math.
So I think if you actually read his memo very carefully, when he used the 300 square feet, he was referencing not just the mudroom, but the stairway.
Well, that's not, he says the
So if
total
you read it,
footprint.
the total footprint of the front mudroom and entry structure is 301 square feet. So he's referring to two things there.
Okay, I don't see entry structure as that different, but in any event, it would, from our standpoint, it's an increase of 153 square feet. And it's not the square footage that is the issue, it's the setback that is the issue. So from the standpoint of, on the east side, which is the road side, when you look at the greatest degree of pre-existing nonconformity, we are 3 feet to the better from where it used to be. Okay, with the pre-existing entrance, that went much further into the roadway right-of-way than it does with the revised plan with the stairs going up each side. Okay, so you're 3 feet to the better on the east side. And on the west side, with regard to the measurements, I don't think you should be measuring from the lake. If you look at Exhibit 5, which is the town lister card, property card, there's a sketch plan there.
Mhm.
The southeast corner of the property has never changed. That has not been reconstructed, no new foundation, anything. So the greatest degree of nonconformity going toward the lake or toward the west is 28 feet plus 6 feet plus 8 feet, a total of 36 feet. Out there last week with Ray's crew, and we measured, and the posts that support the deck are within that 36 feet. So that is that 36 feet westerly of the southeast corner is the greatest degree of pre-existing nonconformity that exists, all right? And with regard to that, when you take that you're 3 feet to the better on the east side, what we are asking the board to do is approve this as it comes to you not only through shorelands, but through conditional use, but because it's an extension of a pre-existing non-conforming structure, it has to go to the DRB for approval. Next, I would like to point out that any ambiguity in your ordinance has to be construed in favor of the applicant, and that's by case law. I point you to the In re Bierke case, and I have copies of these, which I'll give to you afterwards, as well as the In re Barrier Clyde's Camp, I think it's called, both of which talk about resolving ambiguity in favor of the applicant. The ambiguity here is severalfold. First off, the word footprint is not defined in your ordinance. So if you go to your definitions, there's no definition of footprint. With regard to the examples that are in the ordinance, in section 431, I think it is, it talks about, in 431A1, change to the non-conforming element of the structure remains within the footprint of the original non-conforming element or feature, okay? If you then go to A3, it says the change shall not increase the degree of non-conformity or encroachment into a setback. And then in number 5, it says a change will not be considered an increase in the degree of non-conformity, provided that the change does not come closer to the property line or encroach further into a setback or further exceeds the height limit. Then it gives an example, okay? That example is if a house encroaches 10 feet into a setback and an attached deck encroaches 15 feet into the same setback, the house and the deck could be increased in size to the extent that no part of the structure encroaches more than the greatest existing encroachment of 15 feet. The house could be expanded by up to 5 feet, and the deck could be continued so long as it did not encroach more than 15 feet. By definition, you can't do that example in the same footprint. If you're going to increase the house out to what would be the 15-foot greatest degree of nonconformity, you would not be within the same footprint. And so that, in our view, is a direct contradiction in terms in the town's ordinance, and that ambiguity needs to be resolved in favor of the Oldfields. You have the shoreland permit, and we have no problem with any conditional approval of that becoming in its final form because it's a draft permit, and by virtue of that, we're at least able to have this hearing instead of continuing to continue. But I would point out that through that process, the Oldfields did a great degree of mitigation with regard to what you're really concerned about here is the environmental effects. The deck is a pervious deck with infiltration below it that kept and or increased the amount of pervious surface. There's a foundation drain trench that was dug. There are 1,335 feet of new no-mow consideration or areas that don't get mowed that increase the ability of the absorption. The stairs were moved to the inside of the deck on the west side. So all of those we submit are in keeping not only with what the shoreland folks thought was important in granting the permit, but show an overall mitigation in terms of the property and making it fit within the character of the area. And I would also point out that, the history of this is that the Oldfields bought a house that at that point was really falling down and in bad repair. They've done a very nice renovation of it. They hired an architect to come up with the plans. They hired a Vermont builder. They thought they were doing the right thing. They have worked with shoreland permitting all the way through. And we're asking that you approve it as built. Now, I'm sure Ray and Heather, I've probably perhaps forgotten something, but is there anything you'd like to add?
We can sum that up well.
I'm good, Bob.
Okay. And if you have any questions on particular exhibits, we're happy to go over those.
Can we revisit the statement regarding 3 feet of, to the better of 3 feet? Can you
Yep.
explain that one more time?
So my understanding on that is that originally you were 14 feet in the if you look at Exhibit 2, the pre-existing situation there. This is number 2 of Alex's summary. And there was approximately 1 foot from the roadway right-of-way, and the front entrance ramp leading to the enclosed porch was 14 feet long and 13 feet into the road right-of-way. Okay, so now, when you look at the overlay, that entranceway, if you look at Exhibit 5, shows the overlay of the old and the new. Or is it Exhibit 6?
Yeah.
Yeah, it's Exhibit 6. I'm going off mine, but I want to make sure it's the same. Yeah, Exhibit 6. So with the proposed stairs that go up each side, not the stairs that come directly out, okay, which is the new application before you, as the stairs going up each side. That is not as far into the roadway right-of-way as the old ramp, or for that matter, the stairs that exist there presently. And the plan is to change those out, okay? So you're ending up from a public safety, and obviously several of the exhibits are Marshall Dix's concerns originally, and then with this new plan, Marshall saying that addresses the safety concerns. Not only safety concerns, but from a plowing and from the standpoint of not having a wing or a plow wing hit your stairs.
Mm-hmm.
I think everybody's a winner there with regard to that new design. And it lessens the degree of nonconformity on the property by 3 feet.
Mhm. That's what Alex memo says.
Yeah. So We're stating that we think that complies with what everyone's been working toward here. Okay.
Thank you.
Any other questions before we continue? Crystal, you good?
No, I just was.
Diane,
wanted to
any
better
questions?
understand that.
Not yet.
John?
No.
Okay. Thank you.
Okay. Would you like us to sit down in case other people would like to come up?
Oh, no, we have questions.
Oh, you said not at this point.
Well,
Oh, no,
not with
just
respect to your statement.
To your statement,
Oh, okay.
questions for your statement.
Okay. All right.
No, we've got lots of questions.
Okay.
Oh, yeah.
But before we get to those questions, I just want to finish up with the Shoreland Protection Act. That was the only section that we did not discuss in the hearing, the first hearing, because the DEC had not issued a decision. So now we have marked as exhibits, Exhibit 39, which is the updated Shoreland Protection Individual Permit application, and we have a draft Shoreland Protection Individual Permit. So there is a draft permit in place. Correct. Questions there?
No.
Yeah. No.
No. I mean,
Okay.
From the state, that's a state permit. From our standpoint, we've complied. They've issued it. We meet their regulations. And from our standpoint, other than your other issues with regard to the sections on pre-existing non-conforming structures, we would argue that the state permit preempts any local control on that.
Okay.
It is in a 1 month, 30-day.
Oh, I get that.
Yeah.
But what I'm saying is that the elements of it, the state regulations are a state regulation,
Correct.
and it's not for you to second guess their issuing of that permit. It's up to them to issue the permit, not you.
Right.
Yep.
Okay. So I did want to look at one of the exhibits that's attached to the application to the DEC, which is this one, with all the red and dotted lines. It's 3, 4, 5,
Is it out 24, isn't it?
6, 7.
Oh,
No.
I've got it.
I think it's like the 14th page here. And it's in other exhibits as well.
We got it.
You got it? Okay. So the dotted lines show the pre-existing house, correct?
Yes.
And the red shapes show additions.
If you want to call the hot tub an addition, yes.
Okay, so we've talked a lot about the impervious roof mudroom, which is the front. But we haven't talked about the addition that's on the, as I'm looking at this document, on the right-hand side of the building structure.
Mhm.
So that's outside the footprint of the original structure.
That's not ever been raised. Just, he's talking about this
Right.
part here. It's not,
Yeah.
to my understanding, it hasn't ever been raised as an issue or being outside the footprint. And I'm not sure.
In
So
addition, I would say that it is not beyond the dotted line to the north there. So from a pre-existing non-conforming structure, it's no closer to the sideline setback than the prior edge of the house was. So there's no increase in the degree of non-conformity. And from that side yard setback, I don't believe
But it
there's
is
any.
outside the original footprint of the house.
So to your statement, John, that section was permitted by your zoning administrator, Jessica Roberts. So as in the exhibits, they were brought up numerous times that I adjusted the permit on mudroom and deck. That body of that red section you're speaking about right now was permitted and signed off by the town of Wilmington.
Mhm.
So there are no notations in
We have
those.
that amongst all the many exhibits. Yeah.
Okay.
Is it? Do you want me to, I know, it's the planning permit 049, I believe it's attached to that. Which is exhibit,
Okay, no, we can take a look at it later. All right.
sorry, 042.
So that answers that question. Oh, I did have a question with respect to your measurements, Heather. You agreed that the new deck measurement is 576 square feet, but then you went in to say the increase is 416 feet, which is 576 minus 160 square feet. Where did the 160 square feet come from? Because if you look at exhibit 5, it does show the deck. It's not 160 square feet, but 128 square feet.
Yeah.
I think that that's because that's not a rectangle. The pre-existing deck, lower deck, was a, forgetting my
Wait,
geometry.
sorry, could you repeat the question? How did I get the 160? Was that the question?
Yes, that's really the question.
So
Because
we
there's
have here
agreement on
in
576 square feet.
Yeah, in Alex's, this was taken purely from your numbers and Alex's staff summary, by the way, not my numbers, because I don't know much about numbers or architectural plans or anything, but he does say the expansion of 8 by 20 feet rear deck. So I just kind of times 8 by 2 to get 160.
Okay. All right.
Okay, I can throw the numbers.
All right. That's all my questions.
Okay,
So we have the dispute over the measurements.
we do. So the question would be to the Development Review Board, does anybody feel the need for a site visit?
Sadly,
So-
yes.
Yes, and then. Are these increases for more than a 5% increase of the existing? footprint? Yes,
Okay, so we need to look at our calendars. Unfortunately, we will be continuing to a site visit, and then we will be continuing to another hearing to finalize. So if everybody would get out their calendars, please. Diane, how long are you in town?
I'm here.
You're here? Okay.
I mean,
What's everybody's schedule look like? And when I say that, you do not have to be there.
Okay.
But that's entirely up to you. Let me explain this, what we do with a site visit. We won't ask any questions. What we do is we just have to go and we look at it. We need to look at what everything we've discussed, and then because as John said, we do have a dispute. We don't ask for any testimony. So and we won't be.
Do you take are you taking measurements? The purpose of the site visit is to,
We would
Just
we would take
That's
Taking
great.
measurements.
But
measurements,
Alex has been out there.
that's taking evidence.
We're not asking for information. We do look at the site but we will not take evidence in terms of asking for any information from the applicant. So we will not
But
have
you're
a
taking
conversation.
measurements, which are you actively putting something into an exhibit, which, number one, I'm not sure that that is in the purview of a DRB with regard to adding an exhibit to that much.
Well, it certainly is within our purview to have a site visit.
Yes.
Thank you.
You're welcome, you're very welcome to come anytime.
So let's look at our calendars so at this point, our next hearing will be July 6th. So for starters, how's everybody's calendar looking for July 6th? Because this will be continued to July 6th.
I'm here.
I'm here.
Diane,
I don't think I'll be here on this.
are you available?
I'm available,
Thank you. John,
but not personally.
Yes, I'm here.
thank you.
I have a trial either that day or the next, I can't remember, but hopefully the court will be done by 4:30 and give me time to get there.
We do have,
Yeah.
I'll be there and I'll have a load of kids there and my family there, but you're very welcome to come.
no, we will have our site visit prior to that, but I just want to
Oh,
be
okay.
sure that
For the next
our
hearing.
continuation of the hearing will be July 6th.
Okay,
Oh,
I
that's
can,
the
I'm
hearing.
sorry, I
5
can-
o'clock, July 6th. So I just want to be sure that everyone is available for that before we set that continuation.
I'm here at your will. I'm supposed to be away, but I'll come back for that.
Well, you can Zoom. We will have Zoom too.
No, I'd rather be here in person. I'd like to close this out for the old fields.
Well, thank you. But we will have
I
the
understand,
Zoom
Cheryl. I
option.
appreciate that.
Okay, so this will be continued to July, yes?
Can you take any other information from anyone else?
Well, we're going to have a site visit and continue the hearing. So we're not at this point going to take any more information. So we're going to continue the hearing to July 6th. And we're going to now set a site visit. What's everybody's schedule look like?
Checking. What was the second date?
We got the continuation of the hearing will be July 6th at 5 PM.
Well,
Tell me what anyone's available to go to 220 Lincoln
Tuesday or
Pond Road.
Thursday.
this week,
I'm sorry?
Tuesdays or Thursdays.
Tuesdays or Thursdays,
ideal.
okay?
then I can Tuesday or
I mean, tomorrow or Thursday,
tomorrow, I can't do.
or I mean, it doesn't have to be this week.
All right,
Try to think. What
I'll
What
be
day do you
disagreeing
think?
with Danny now.
so
We're-
I'm just
We're-
making sure that these guys will at least be there to let you in if you need to go inside or be there. So
let me just,
What day are we talking about?
Crystal's only available Tuesdays and Thursdays. It
I
could be
can make-
this week or next
I can
week.
make it either Tuesday or Thursday.
I'm good, so just tell me, do you want to do the 23rd? Is that, you, Diane,
I'm here. I can do the 23rd.
you can do the 23rd. Diane, can you do the 23rd? John's shaking his head. Nope,
23rd.
John can't do the
I have a
23rd.
board meeting.
okay.
Okay, all right, so
25th?
25th.
Are we talking in the late in the
No, I
day or
can't.
morning?
no, okay, so what about this week? Do we
Morning or
want
End
to,
of day,
16th.
sorry,
what was that?
morning or end of day?
We could do end of day.
Could we do Thursday, the 18th?
I can do it after 4:30.
Okay, I have another meeting in Brattleboro at 6. I guess that works.
How long do
4:30.
you feel the,
How long do you think it would take? More than half an hour?
No,
Okay, then I can do the,
can you be there at 4:30?
sure.
I have a child graduating that day, so I'm not there. Sorry.
So our site visit will be June 18 at 4:30. We're all set, so we are continuing. Thank you very much. And we will see whoever's available on the 18th at 4:30 at 220 Lake Raponda. And then we will be back here for continuation of this hearing on July 6th at 5 o'clock.
Okay, and what's the case I'm supposed to read?
And can I ask is the continuation for extra questions, extra time, like the continuation is?
Well, it's a continuation of the hearing, so there'll be, there can be more exhibits, there can be all kinds of stuff.
Right.
Yes, I mean, it's a continuation, so there's no limitation on the continuation.
Okay.
Right. So thank you for coming, and we will see whoever's there on the 18th, and we'll be back here on the 6th.
Thank you.
Thank you.
Have a good evening, everybody.
Thank you. And we'll be with you in a minute. We've got so much to pack up here. Right?
Why don't you have everybody do it,
And we're going to open the hearing on application 2026. Come on up, Lisa. 048, the property address is 22 West Main Street. The owner is Judith Klein, and the agent is Lisa Sullivan. The proposal is a conditional change of use in the Historic Design Review Overlay District, the Flood Hazard Overlay District, and the Village Zoning District. The proposed use would consist of expansion of Pickwell's Barn and existing clothing retail business into a portion of the subject property previously occupied by McGrath's Art Gallery. The applicable code sections are Article 2, Section 221, 222, 223, 226, 271, 272, Article 4, Section 420, 440, 450B, Article 5, Section 520, 521, 522, 530, 540, Article 6, Section 603, and Article 7, Section 710, 720, 721, 722, 723, and 730A. And yes, we have, yes. Yeah.
That was
It's
a
a
long list.
It's a lot. So Lisa, would you please raise your right hand? Do you swear that testimony you provide is the whole truth and nothing but the truth?
Yes.
And I'd just like to make sure there are no conflicts of interest or ex parte discussions to the board. Thank you all so much. The DRB puts together a case manager, and Diane is going to run us through your case.
Okay. Right. So, all right, I'm going to start with the exhibits. I've got exhibit 1, the cover sheet, exhibit 2, the summary from the zoning officer that Cheryl just read from. Exhibit 3 is your application. There are 2, exhibit 4, I've got 2 pages of site maps that show the flood hazard zone and that the property is within that flood area. Exhibit 5 is an email, which it has the most recent water and sewer bill, and from what I can see from that, there's no changes to plumbing or adding.
No, we're not making anything like any changes like that.
Exhibit 6 are 2 hand-drawn floor plans showing this building and its use and size. And then exhibit 7 is 8 pages of your, I guess, a permit result looking through the Agency of Natural Resources and the NRB, or Natural Resources Board, which is kind of a questionnaire. It's fine. And then I think last, the abutters list and warning notice. Okay. All right. This is like pretty straightforward application. You're here really because doing any kind of use in the village, such as retail, is a conditional use, so, which is why we're here to kind of review it. But is in terms of the, if you, maybe you can tell me a little, or if what I'm saying about your project is that you're not making any changes to the building on the outside.
Correct.
You're simply expanding the Pickwell retail space into the gallery. You're not making any changes to the outside. There's changes on the inside. I mean, are really not
really.
relevant.
I mean, yeah, we're not doing anything to the building envelope at all.
Right.
It really is just a change of use that we're asking. So it was an art gallery. It's been an art gallery for, I don't know, a lot of years. And now we're wanting it to be retail.
Seems very straightforward.
Pretty straightforward, yeah. We will sell some art as well, I think. But.
Oh, good. We like art. All right, so we pretty much just sort of touched on the district and uses. You're sort of in the trifecta, where you're in the village district, the historic design review, and also in a flood zone area.
Mm-hmm.
So as far as the village and historic districts, you're not really making any changes to the outside, and it's really a continuation of an already very successful business that brings a lot of value to the town. I mean, I don't think there's really much to go over on section 4 or 5, right?
I mean, we have to go through 7 because we always have to go through 7.
Yeah, but again, there's no changes to the building. This is no impact, other than, more shopping. Let's see, the other part of this, I guess, and then even as it comes, I looked at the section 6, which goes into the flood district and whatnot. Having read through that, again, my take, and board members, please, chime in. But again, because there's no changes to the building, you're not, the use of that space as a retail is not creating any more of a flood hazard or making any sort of impact to the zone, to that in any way that I can see. So again, I felt like that conditions seem fine. We don't really need to, nothing there that sends off any flags. And then just as part of the formality and practice of what we do as the DRB members, we kind of have to go through our section 700, which lists the general standards because you are doing a change of use. So I will go through these sort of standards questions, and you can respond to them in terms of, So, all right. So beginning with 721, the general standards, and this I won't put you through, but basically there's 6 criteria. They're labeled A through F, and they have to do with the capacity of existing or planned communities, traffic on roads and highways, bylaws and ordinances in effect, utilization of renewable energy, air quality, and character of the area. And this is a project that does not have any undue adverse effects on any of those items I just ticked off. So we can continue. Section 722, conditional use, preserving the character of the town. And I think we can all agree that the expanded Pickwell barn is a continuing use of a business that is adding a lot of value and character to the town. So I think we can move through that one. Historic preservation, again, you're not making any changes. This is a building that is on the historic registry of both Vermont and on the national level. But again, no changes there, so no impact. Then we get to section 730, conditional use specific standards. And then I'm going to go read through these lists and I'll give you an opportunity to respond. So, will there be any changes to any of the lighting on the outside of the building?
No.
Is the lighting that's there now downcast and shielded?
I believe so. There's not very much lighting on the outside of the building, but what I think there is yes, downcast and shaded.
Downtown, right, it's
Yeah.
like spotlights that are going out. and
Right.
Blinding drivers.
Yes, I don't think we're blinding drivers.
Okay. All right. You had only A listed,
That's
Cheryl.
not- I'm sorry,
You had only A listed because all the other ones.
because all the
again,
rest of them,
Are all not applicable.
yeah, I only
because,
put in A
again,
because that's the only
that
one.
would be the only
yeah.
one. So there's a bunch of others, traffic, pedestrian safety, again, not applicable, commercial parking, not applicable, road development, not applicable. You're not doing any landscape screening and development.
No.
Land and water management, natural resources, wildlife protection, not planning on, changing the bear habitat or anything.
No, not touching the bear.
Shoreline
The
protection.
bear will show up no matter what.
Yes, they.
And you already mentioned that you're not making any changes to plumbing fixtures, so you're not adding more waste. You're
Right.
not increasing any
No.
wastewater or use there of the sewer system. That's everything. Anybody have questions?
Questions, Crystal?
No, I mean, entrances stay the same, right? There's no change to how people engage with the building.
Right, yeah, we're not
Entrances are-
adding any
Yeah.
entrances, yeah, no.
John,
Seems
questions?
pretty straightforward.
Yeah. I think it's pretty.
Thank you so
All right,
much for
thank
coming. We will now close the hearing.
Okay, thanks.
Thank you.
Thank you.
Have a good night.
Good night.
Thank you. So I have no new or old business. And so I'm going to close the meeting.
Great.
That was discriminatory and wrong, what you did tonight. You have a posted agenda for public comment, and you discriminated against me by not letting me speak. And in actuality, what I was going to say was April 6 minutes, when you were going to approve them at that meeting. Charlie couldn't be heard and couldn't engage with the board. And he kept saying, "Can you hear me, Charlie? Can you hear me, Charlie?" And you went to a thumbs up. You had 4 members of your